Just a quick disclaimer. The information in this presentation is intended for informational purposes only and should not be considered legal advice. You're strongly encouraged to consult your own legal counsel to ensure compliance with applicable law in your specific state, municipality, or jurisdiction. So some of the new laws that have come up in 2022, Governor Newsom signed 997 new laws on various topics, some of which we're going to discuss today. And these are the ones that are important for California employers. So we have extended COVID paid sick leave, limits tests and policies regarding marijuana, a new law regarding bereavement leave, expanded law on pay transparency, and some other important topics. So some of those topics include, like I mentioned, the COVID-19 regulations, some regulations regarding the testing of employees for marijuana use, bereavement leave, also SIFRA leave, emergency time off, pay transparency and reporting, the California Consumer Privacy Act, Cal Savers, some information regarding fast food employers, workplace violence, information on call centers, call center relocation specifically, farm worker unions, minimum wage, suitable seating. There's been a new EEOC poster, and then a new I-9 form is in the works as well. So to dive in, the California Department of Public Health revised its definition of close contact, and they kind of clarified what is considered an indoor space. They had basically just left it that if someone was around an infected person during their infectious period, in the same indoor airspace, then they would be considered a close contact. It didn't really define what indoor airspace was. And I know that there were employers that had some confusion about what that actually meant. So the California Department of Public Health clarified and stated that in indoor spaces, 400,000 or fewer cubic feet per floor, a close contact is then defined as sharing the same indoor airspace for a cumulative total of 15 minutes or more over a 24-hour period during an infected person's infectious period. And then in large indoor air spaces, which are considered greater than 400,000 cubic feet per floor, a close contact is defined as being within 6 feet of the infected person for a cumulative total of 15 minutes or more over a 24-hour period during an infected person's infectious period. So that last one is somewhat similar to what we had before, where we have the 6 feet of distance rule there. So they further clarified to say that spaces that are separated by floor to ceiling walls, such as offices, suites, rooms, waiting areas, bathrooms, break or eating areas, those are considered distinct indoor air spaces. So if you have a layout where all employees have their own office and that's separated floor to ceiling walls, then you're a little bit safer than if it's an open floor plan situation. So extended COVID supplemental paid sick leave. So this extends benefits for employers with 26 or more employees to December 31st of 2022 instead of expiring in September. So there's no additional time that's available. It's only the time to take the leave has been extended. And just to do a bit of a recap, employees have 40 hours of paid sick leave if the employee is quarantined, has been advised by a healthcare provider to quarantine, or is experiencing symptoms and are seeking a medical diagnosis. Or the same thing for a family member, is caring for a family member who's either subject to quarantine or isolation, has been advised by a healthcare provider to quarantine, or if the employee is caring for a child whose school or place of care is closed or unavailable due to COVID-19. There's still the up to 3 days for obtaining a COVID vaccination and the recovery from the shot. And then you have those additional 40 hours that kick in if the employee or a family member who they're caring for tests positive. So a positive test in this case can be required as well. So the previous law allowed an employer to require the employee to take a diagnostic test on or after the 5th day after the initial test. So the initial test is the test that they tested positive for and qualify for that extra 40-hour bucket of supplemental paid sick leave. So an employer was allowed to require the employee to test again on or after the 5th day and provide the documentation of those results. So now, as amended, the law states that if the diagnostic test is positive, the employer may also require that the employee submit to a second diagnostic test within no less than 24 hours. So that's a slight change that they've added in there. As well, previous law had stated employers did not need to provide 2022 supplemental paid sick leave if an employee refused his or her employer's request to provide documentation of the test results. So as amended now, employers can also deny 2022 supplemental paid sick leave to an employee who refuses to take the diagnostic test. So that's either that diagnostic test on day 5 or the one within 24 hours after that. So if either the diagnostic test or this second diagnostic test that they take within 24 hours after the first is negative, then they no longer qualify for any extended supplemental paid sick leave after that negative test. Also, AB 152, which had extended that time for supplemental paid sick leave to December 31st. It also established a grant program for certain small businesses, around 26 to 49 employees. So the grant would provide up to $50,000 to cover some costs of the COVID-19 2022 SPSL that was provided. There's a lot of specifications, and I've tried to get in contact to see how clients and employers can apply for this grant program, but it doesn't look like the Labor Commissioner has really put the plan in place quite yet. But this is something good to discuss with a CalWORK safety team member or your legal counsel to see whether or not your business may qualify for this grant. So the COVID-19 state of emergency, on October 17th, 2022, about a month ago, Governor Gavin Newsom announced that California's COVID-19 state of emergency would end February 28th, 2023, which is about 3 years from its initiation. So the state of emergency had been extended 5 times over the duration of the pandemic. And this gave Newsom very broad powers to issue masking mandates and temporary stay-at-home orders in an effort to try and slow the spread of the virus. And then something that's been extended to January 1st of 2024 is the presumption for workers' compensation regarding COVID-19, that a COVID illness is work-related and thus covered under workers' comp. So that's why it's really important for employers when they have an employee who has tested positive to do an investigation to determine whether or not it was work-related or have some evidence in place to verify that it wasn't work-related. Maybe they told other employees or told you during the investigation that they had family members at home that had COVID or had gone out to an event where maybe it was a super spreader event and people caught COVID. You want to have all of that documented and written down to try and fight this presumption that the COVID was obtained at work. This is regarding COVID exposure. When an employee in the workplace tests positive for COVID, it no longer requires a written notice to each employee if they were a close contact. So what we have currently in place is that you have to notify every close contact of the COVID-19 that was a close contact to the COVID-19 employee, and have to let them know that they were a close contact, give them information regarding benefits, the cleaning procedures and protocol that the employer plans to take, and some other various information. So beginning January 1st of 2023, this is no longer required. You more or less now have to just put a poster that needs to be kept up for 15 days, and it has to be in a language that your workforce speaks. And another additional item is that the notice to the local public health agency will no longer be required when there is an outbreak. Another important thing to note with Cal OSHA and the COVID regulations are that the current Cal OSHA emergency temporary standards regarding COVID-19 will expire at the end of this year, so December 31st. Cal OSHA is expected to issue a new and permanent regulation either sometime this month or December, and the proposed regulation does not include any requirement for wearing masks and eliminates exclusion pay. However, this is still proposed. We haven't found out yet what the regulation will actually be. We probably won't find out for a bit. It doesn't look like there's been a lot of movement for the proposed regulation. So another important change in the law to note is regarding testing for marijuana use. This is something to know that doesn't go into effect until January 1st of 2024, but it's still something important for employers to keep their eye on, just in case they have to change policies and want to get started earlier rather than later. So it'll be unlawful for an employer to discriminate against a person in hiring, termination, or any term or condition of employment based upon a person's use of cannabis off the job and away from the workplace, except for pre-employment drug screenings or reasonable suspicion or post-accident tests. And an employer may not use an employer-required drug screening test that reveals non-psychoactive cannabis metabolites in samples of hair, blood, urine, or other bodily fluids. So this is something important to keep a note on, because a lot of drug tests now do reveal the non-psychoactive cannabis in there, and when it really should only be searching for the parts of the cannabis that are causing impairment. So that's going to be a big switch come 2024. That'll be really important for employers to remember if employers are doing drug screening, drug testing, and they are looking for marijuana use. So it's also important to know that this is a law that protects employees who use marijuana off work time. So this is during personal time and away from their job. This does not at all kind of hurt employers from creating a drug-free workplace. Employers can still maintain a drug-free workplace, but now these tests can only check for active THC. So it's not residue, which can stay in samples after impairment no longer persists. So THC is really the part that's causing the psychoactive impairment and results. Another important change was bereavement leave. So bereavement leave was something that used to be an optional provision if employers wanted to give employees bereavement leave. Now it'll be something that's required if an employer has 5 or more employees. An employer will have to allow 5 days time off for bereavement leave for death of a family member. And family member under this law is considered a spouse, a child, parent, sibling, grandparent or grandchild, parent-in-law, or domestic partner. And this time is unpaid unless an employer already has a paid bereavement leave policy. So this means that if your business currently has a bereavement leave policy where you pay for 3 days for bereavement leave, those 3 days would still have to remain paid, but you'd give those other 2 days as unpaid. You don't have to also pay those 2 additional days that you have to provide under this law. Also, to qualify for bereavement leave, an employee must have been employed by the employer for at least 30 days prior to the time that they take the leave. And bereavement leave must be taken within 3 months of the death. So if someone dies, a family member dies in January, they can take that time off the next month in February, next month in March, if they choose to do so. An employer can also allow use of vacation or paid time off if the employee does want to receive pay for the time that they are taking on bereavement leave. And this becomes effective January 1st, 2023. Another pretty big change was CFRA. So currently under CFRA, employers with 5 or more employees currently must allow unpaid time off for their own serious health condition or to care for a family member with a serious health condition. So it's now been amended to extend the benefit to cover time to care for a designated person who is considered the equivalent of a family member. And the law defines this as any individual related by blood or whose association with the employee is the equivalent of a family relationship. So employers can limit this to 1 designated person per 12-month period. So that kind of helps employers a bit. So that way there aren't employees kind of taking CFRA leave often for different designated persons. The employer can limit this. And this also becomes effective January 1st, 2023. So the law that I mentioned previously also changed a bit for the kin care leave. So kin care leave is basically what kicks in when you're providing an employee their California required paid sick leave and they want to use that time to care or provide treatment for a certain family member's health condition. So now this new law also includes a designated person to the list of family members. And designated person is considered a little bit different, defined a little bit differently for kin care leave. It's really just defined as a person identified by the employee at the time the employee requests use of paid sick days. It's not as specific with the CFRA, with the family relationship equivalent. It's really someone that an employee can identify and consider their designated person at the time they request the use of their paid sick days. And in this case as well, an employer can limit an employee to 1 designated person per 12-month period. This also goes into effect January 1st. So time off for emergency conditions. This one is a bit different than leaves that have come in the past. So if an employee has a reason to believe that their worksite is unsafe during an emergency condition, they can be protected for refusing to report to the worksite or leaving the worksite. So an emergency condition means either the existence of condition of disaster or extreme peril, to the safety of persons or property at the workplace or worksite, which is caused by natural forces or a criminal act. Or it can also mean an order to evacuate a workplace, a worksite, an employee's home, or the school of an employee's child due to a natural disaster or criminal act. It's really important to also note that an emergency condition does not include a health pandemic. The law clearly carved out a health pandemic in there, likely given what we've seen with COVID-19 and monkeypox, things like that. So there must be a reasonable belief that there's a real danger of death or serious injury. And if feasible, the employee must notify the employer when the employee refuses to report to work or is leaving work. This law also allows employees to use their own cell phones to seek emergency help. And this isn't something that will get rid of your no cell phones on the work site policy, anything like that. This is really just for use in an emergency situation and when an employee is using their cell phone to seek emergency help. So another big law for employers to take note of are the pay transparency laws. So an employer, upon reasonable request, must provide the pay scale for a position to an applicant applying for employment. So you're required to give any current employee a copy of the pay scale of the position they hold if they ask as well. And those employers with 15 or more employees must include the pay scale in any job posting. This also extends to any third-party company the employer is engaging to publish a job posting. So just because this isn't on your actual company site, the job application or the job posting, say that this is on Indeed or Glassdoor, that also has to have the pay scale in that job posting. And there is a bit of contention as to what pay scale means. The law says that it's the salary or hourly wages, and a lot of law firms have kind of come to the conclusion that that means the base salary pay, the base hourly pay that doesn't include benefits, commission, any non-discretionary or discretionary bonuses. California might decide to kind of change that and want to include that later, but for the time being, that would just be the base pay that you have to post, or the base pay scale that you have to post in the job posting. It's also going to be a required record keeping of every employee's job title and pay rate history while employed, plus 3 years thereafter. And this becomes effective January 1st, 2023. So if you don't already have pay scale set up for a lot of your positions, now would be a good time to start working on that, see what competitive pay scales are, see what your company has budgeted to try and determine that and get those up before January 1st, 2023. Another change is pay data reporting. So if an employer has 100 or more employees, they must report pay annually. And the pay data now must include the number of employees by race, ethnicity, and sex, report by job category, and number of employees in each of the 12 rate bands. So this does not affect the requirement of employers to file reports pursuant to existing law through December 31st, 2022. So those you'd still have to file your reports the way you've been doing them pursuant to existing law, but now this is going to take effect January 1st. So you're going to submit a separate pay data report for employees that are hired through any staffing agencies, temporary help firms, or labor contractors, including ownership names of all such firms. And another additional requirement is reporting the median and mean hourly rate for each combination of race, ethnicity, and sex for both direct employees and those hired through other firms. And basically what the point of this slide and the last slide, the pay transparency and pay data reporting, the government is trying to see if there's any pay discrepancies between race or any other type of protected characteristic. So some timelines. The pay data must be submitted to the state by the second Wednesday of May each year, starting in 2023. So your first report deadline for 2022 would be May 10th of 2023. You're going to want to separate your reports for each work location because you can no longer submit a consolidated report. So some tips for getting started regarding pay transparency. Want to determine and document the wage or pay ranges for all your positions. You're also going to want to decide how you will answer pay range questions that are brought up to you by your employees or applicants. Confirm with any staffing or temp agency that you use that they'll provide the needed data and also ownership info of the firm. And if you're over 100 employees, you're going to want to assemble the required data by subgroups. So meal and rest breaks. I'm sure a lot of you all are familiar with paid rest breaks have to be given at least 10 minutes of a rest break per 4 hours or majority thereof must be given. So uninterrupted unpaid meal periods of at least 30 minutes per 5 hours worth must be provided as well. And then those who do not receive paid rest breaks or their uninterrupted meal period will receive 1 hour of premium pay. And that's per violation of rest and or their meal period. So this includes short, missed, or late breaks. And according to the California Supreme Court, these rest breaks and meal period premiums are considered wages. They're not considered just penalties, which means that now they must be included on pay stubs. So if you have someone that missed their meal break and they were paid a premium for that, you're going to want to include that specifically on their pay stub. That'll be an important thing to note. This was part of the holding in a case from the California Supreme Court this year. So these meal and rest breaks are subject to a 3-year statute of limitations. And if an employee does not clock in and out for meal periods, this can be considered a red flag and a potential violation. So that's why it's very important for all your non-exempt employees, make sure that they clock in and out for meal periods because it's really important if anything comes up that you have all the records showing that they did take their meal periods and did take it for the correct allotted amount of time. You can also ask employees to attest that they were provided the opportunity to take required meal and rest breaks. I know a lot of employers find it hard to track rest breaks given that they're paid and the employee stays on the clock, but it's a good idea to have them attest that they were provided the opportunity to take the required meal and rest breaks, just because in case something comes up and the employee tries to sue the employer, the company, claiming that they weren't allowed to take rest breaks, didn't have the opportunity to do so, you can look back on that documentation and provide that to the court or to the commissioner's office if the occasion arises. So the California Consumer Privacy Act, this will be effective January 1st, 2023. Employers will have to comply with notice and disclosure requirements regarding personal information collected from employees and job applicants. So a good thing to note is that this only applies to businesses which have gross revenue of 25 million per year or buy, sell, share personal information of consumers. We highly recommend that this be included as a provision in employee handbooks. We have the provision at CalWorks Safety ready to include in any client handbooks if they fall under and are covered under this act. So some of the requirements under the act are that employees must be given notice of types of personal information collected. They must be given the right to request correction of info or deletion of info. Employees may request that personal information disclosure be limited. Employers may maintain information needed for payroll, benefits, etc. And employees may only change personal information if reasonably verifiable, such as proof of a changed social security number. CalSavers. So I know a lot of employers were affected by the CalSavers retirement savings program this year because it now applies to all employers with 5 or more employees. So this is where employers must enroll and allow employee deductions for a state-sponsored retirement plan unless they don't offer a 401k or other qualified program. So by December 31st, 2025, this requirement will apply to employers with 1 employee or more. So it's important for a lot of very small employers to know that in the coming couple years, this requirement will also apply to your business as well. So the AB 257 Fast Food Council is created, and it applies to fast food restaurants which have 100 or more locations. So the Fast Food Council can set minimum wages above regular rates, and it's estimated to be $23 per hour in 2023, as well as certain working conditions, safety conditions, and working hours. So this expands joint liability for franchisors regarding actions of franchisees. And this also applies even if you only own 1 franchised restaurant and you don't own 100 of them, but that franchisor has 100 locations, you would still fall under the guidance of this fast food council. So the Workplace Violence Prevention Program, this was something that Cal OSHA was supposed to have come out with and put out a regulation for. The effective date right now is unclear, but it'll likely come up again early 2023. And this would require all California employers to have a written violence prevention plan or include it in their illness and injury prevention plan. This would also require employee involvement in developing a plan and assessing risks of violence, and requires employee training on violence prevention and keeping a violent incident log. So this is somewhat similar, these last 2 points, to employers' COVID prevention plans, where it really asks employees to be involved and to help the employer determine what risks are, what hazards there might be. But in this case, it's for violence. And you're also going to have that employee training similar to the COVID prevention plan training. Some information regarding call center customer service employees. It now requires call center customer service employees be provided a 60-day notice prior to relocating to a foreign country. So now those call center customer service employees will fall under the WARN Act. Agricultural unions. So under AB 2183, this creates a card check process as an alternative to a secret ballot election or a mail ballot for union status. And farm employers facing union organization attempts should seek legal counsel to evaluate the best response. So this really gives agricultural workers the option to vote by mail. And that's a little bit different than what it was before, which had to be an in-person vote. So employee-only restrooms. I thought that this was something different and something important for certain employers to note if they have employee-only restrooms. So California law is, will be January 1st, that a business that is open to the general public for the sale of goods and that has a restroom for its employees now must allow any individual who is lawfully on the premises of that place of business to use that restroom during normal business hours, even if it's typically held out to be an employee-only restroom. There are some caveats to this. So this is if the individual requesting the use of the restroom has an eligible medical condition, and these medical conditions are things such as Crohn's disease, an inflammatory bowel disease, IBS. There's certain conditions that fall under this eligibility. If 3 or more employees of the place of business are working on site at the time that the individual requests to use the restroom is not located in an employee changing area or an area where providing access would create an obvious health or safety risk to the requesting individual or would create an obvious security risk to the business, that use of the restroom would not create an obvious health or safety risk to the requesting individual, and a public restroom is not immediately accessible to the requesting individual. So this is some important carve-outs to know. And also, it's important to know that as a business, you can ask for documentation of the eligible medical condition as well. So California minimum wage increase. As of January 1st, 2023, California state minimum wage increases to $15.50 per hour. The minimum wage increase also does affect the minimum salary requirement for exempt employees to $64,480 annually. So it's a very important time to review the salaries of your employees currently classified as exempt and see if they are close or at the new annual required amount. A lot of the times, employers know that the state minimum wage is increasing, but don't realize that the minimum wage increase does also affect the minimum salary requirements as well. So some specific Southern California wage increases. As of July 1st, 2022, following jurisdictions have increased their minimum wage rates. We have the city of Los Angeles, unincorporated LA County, Santa Monica and Malibu, Pasadena, Long Beach, and West Hollywood. And these all have specific rates per hour, and some are extended based on the size of the employer or if it's for a hotel employer. The IRS mileage reimbursement rate, another important change to note was that on July 1st, 2022, the IRS increased standard mileage rate for business travel from 58.5 cents to 62.5 cents per mile. And this can be used to meet the California legal requirement to reimburse personal expenses incurred in performing a job. But the rate may increase starting the new year given the inflation. So some minimum wage increases for healthcare employees. In the Los Angeles area, including city and county and various other local cities, there is an ordinance requiring a minimum wage of $25 per hour for employees of privately owned healthcare facilities, such as general acute care hospitals, skilled nursing facilities in clinics, which are a part of general hospitals, and dialysis clinics. So it'll be really important to check your local jurisdictions regarding the current status of local ordinances. So California exterminators and workers' compensation. California exterminators are now required to provide proof of continuing workers' compensation coverage to their state licensing board in order to maintain their registration. Before, this wasn't a requirement to get their next year's registration, but now they have to provide proof of that continuing workers' comp coverage. Suitable seating. California law requires employers to provide suitable seating when the nature of an employee's work reasonably permits use of seats, or for jobs when standing is required when use does not interfere with their job duties. When employees must stand throughout the workday, you should evaluate if seating can't be provided and if a written policy is needed. Typically, this comes up for cashiers, at checkout stations. You'd want to consider including seating. This is actually an important law where job descriptions matter. So if you have a job description of a cashier where the cashier's only duties or are to work the register, they'd be standing in that one place, and California law would likely find that suitable seating could be required. However, if their job description says that cashiering is just one part of their duties, they also have to clean around their vicinity, stock shelves, do go backs, what have you. That could be more in employer's favor, that suitable seating would interfere with their job duties. So it's something to note when looking at your job descriptions to see how they're written and to determine if suitable seating would be allowed for that position. So a new protected category under FEHA, an employer is prohibited from discriminating or taking adverse action against an applicant or an employee based on reproductive health decision-making under FEHA. It's now unlawful for employers to ask about an applicant or employee's reproductive health decision-making. California did this pretty much in a response to the Dobbs case, which was taken by the US Supreme Court, which overturned Roe versus Wade that happened recently. So this becomes effective January 1st, 2023. New EEOC posters. So employers are now required to post the EEOC's new poster, which was issued the end of last month in their premises in a place that's often frequented and where you have your other employee posters. Would be a good place to post this new EEOC poster. It could also be posted electronically if you still have a lot of remote workers, and failure to do so is punishable by a fine of $569 for each separate offense. So this is what the new poster looks like. It's 2 pages. Please reach out to your CalWorks safety and HR consultant if you need this poster. I believe it's in English and Spanish. It might be in a few other languages as well, if you need that for your workforce. So new I-9 forms. The Department of Homeland Security has announced that employers must continue to use current I-9 forms even after the expiration date. So the I-9 form that everyone's currently using, it was supposed to expire at the end of October. However, it seems like the Department of Homeland Security, they're making a lot of changes to the form I-9, the I-9 form right now. So the new form is likely going to come out in 2023. So keep filling out the forms the way you're supposed to with the same form for now until we receive word of the new I-9 form. That pretty much rounds out the most important 2023 employer labor laws. If you have any questions, please feel free to ask in the chat or contact your CalWorks safety and HR consultant if you have questions very specific to your company, or if you want to find out more about the city or county you're working in and see if there's any specific regulations there as well.
All right, we got a couple questions here. One sec. If any employer determines that an employee has been in close contact with a COVID positive employee, are we mandated to have them test? Can or should we mandate they test or just make testing available?
You can make testing available. It kind of depends on whether they have symptoms as to when they'll test. I believe if they're symptomatic, you want to have them test right away. And if they're asymptomatic, I think you wait 3 to 5 days before to have them test to see if kind of they get those symptoms. But yeah, that's all on the California Department of Public Health has isolation and quarantine table, or if you've received a COVID-19 packet from CalWorks Safety and HR, that'll be on that table as well, and it'll have the testing guidelines for any close contacts.
Is there any word of if employers will receive any type of tax credits from the state for COVID sick pay?
Tax credits, I haven't heard anything about any tax credits. The only thing that I'm aware of right now is that grant that I had mentioned for those smaller employers, 26 to 49 employees.
What if they were just in the building and not considered a close contact?
You'd have to look at the same thing that I mentioned. So if they weren't even in close contact, they weren't around anyone for that 6 minute period or in the same indoor airspace, then yeah, they wouldn't be considered a close contact and you wouldn't have to send out the notification. So you would just have to check to make sure that it wasn't in close contact within that person's infectious period to be sure.
The printed document regarding notice of COVID exposure states effective 1/1/24, but you verbally advised 1/1/23, which is the correct date.
Oh, okay. That might be a typo on the slide, or it could have been that that's in effect until January 1st, 2024. A lot of these Cal OSHA laws and regulations are kind of for limited time periods. It's not something that's kind of ongoing. So it could be that it takes effect actually January 1st, 2023, and then is in effect until next year, 2024.
Does missed meal period 1 hour penalty count towards overtime hours?
No, it doesn't. Yeah, overtime is only the hours actually worked.
What type of proof can be requested for bereavement leave?
Bereavement leave, it can be death certificates. There's a few different ones. Death certificate, I think, from the funeral site. There are a few different ways, but that's your main one would probably be a death certificate that you'd ask for.
If tested pre-employment and employee tested positive for THC, can I rescind the offer?
Right now you can, and it seems like 2024, you might be able to do that as well if it's positive just for the active THC. And you just have to really make sure that it's not also showing the non-psychoactive results. So that's kind of an important thing. Just make sure that your test is actually just checking for the active THC, but that's something that doesn't come into effect until 2024.
We use another earnings code for penalty pay to see how much we pay out for meal periods. Is that okay?
If that, I guess the notification, if it says meal period premium or rest period premium and can be deciphered on the pay stub as that by the employee, then that should be fine. So you just want to make sure that it clearly states that that is the premium pay for a missed meal period or a missed rest break.
Still confused if employers are mandated to test employees after a known exposure at the office or just make testing available.
So they should have employees test. The testing, of course, is available, but you should have employees test in order to determine whether or not they can return to work if they either have tested positive or either test negative. There's kind of different criteria that you have to follow, but you should have them test and you'd have to pay for the time and the test.
Okay, and regarding this question, if anybody would like a copy of the slides or a video recording of the presentation, reach out to info@calworksafetyhr.com. Another question here. So no more general notices of potential COVID exposure are required for anyone in facility or work area of infected person?
No, so it's going to get rid of that and it's going to have just the workplace poster. So this makes it easier for employers who might have a workforce where they don't all have like work company emails, or may not have the use of company cell phones, things like that. Sometimes it's more difficult to get in contact with some employees. So long as you have it posted in a visible area, maybe the same place where you post your employment posters, or a break room, somewhere like that.
If the employee chooses to not take the meal break by the 5th hour, can they ask to waive this requirement? If yes, does the employer still need to pay the 1 hour penalty?
So an employee can waive that meal break period, but I believe it has to be when they're working a shift of 6 hours or less, and that meal period waiver should be in writing. You shouldn't allow employees to waive their meal period if they're going to be working, for instance, a full shift of 8 hours. You should have them still take that meal period, because yeah, you will have to end up paying that meal period penalty.
All right. Do we have any more questions in the chat? Let's see here. So if you have more than one employee test positive within the 15 days of posting notice of previous COVID positive test, do you just keep posting new ones with new dates alongside each other?
Yeah, so you would post the new poster, and you could, yeah, keep those up for 15 days. But it's really important to note, if you have a situation like that where you have 3 employees that have tested positive within a 14-day span, that would be considered an outbreak. And there's other guidelines that you have to follow in order to be compliant under Cal OSHA's ETS.
All right, any more questions? All right, thank you so much, Kayla, for sharing. This is an important topic, and remember, if we didn't address your questions today, go ahead and reach out to us at info@calworksafetyandhr.com. Excuse me, calworksafetyhr.com. Again, please be on the lookout for future topics on our website at calworksafety.com. Thank you for joining us. Have a wonderful rest of your day.